And right out of the gate, the judge isn't easing into this, they're bulldozing straight through denial. This isn't a misunderstanding, it's a credibility problem. When a judge starts by calling someone delusional, you're already digging out of a legal hole.
This time around.
Anything you want to say prior to sentencing? You're delusional. Like this, what you said in here about what your recollection of what happened was, the probation department, like your lack of accountability on this, and you had 2 shots and 2 mixed drinks. You came in at a .204.
That was what I remembered.
Okay, well, it's inaccurate. I
I understand that.
Listen to me.
Let the judge talk.
It's inaccurate. That's not what happened. You were drunk driving at almost 2.5 times the legal limit with kids in the car. But it's cool because they had seatbelts on. You're going to do 12 months probation. You have a fine of a payment plan over the course of your probation if you need it. You'll have 12 months probation. You have 5 days or 40 hours of community substances unless prescribed by a physician. Documentation will be required for the term of probation with.
Let's pause here. A BSE of .204 is not a few drinks. That's more than twice the legal limit, and with kids in the car, this crosses from reckless into outright dangerous. Seatbelts don't cancel out impaired judgment.
Yes. Is that a yes?
Yes.
Okay. If I walked into court, you just seem very defiant. This PSI investigative report indicates that to me with the probation department as well. And I just cannot imagine getting caught. Well, I can't imagine doing it, but I certainly can't imagine getting caught drunk driving with young children in the car, and coming in and having a BAC so high, having a blood result 2.5 hours later, you were still twice the legal limit, and coming into court in any way other than ashamed of myself and meek and embarrassed.
I am.
Okay, you should be.
Okay, go ahead. Can I just say something? When I got arrested, I immediately went to the hospital. It wasn't 2 hours later.
By the time the blood draw came in, so you go to the hospital, they have to do a search warrant, and then after they do the search warrant, they have to draw your blood, and they mark and identify the time of the stop, and they mark and identify the time of the.
This is the moment judges look for accountability, and she's missing it. Courts don't expect perfection, but they absolutely expect humility. When someone shows up arguing instead of apologizing, consequences tend to multiply.
Blood draw, and the blood draw was 2.5 hours after the stop, and all of that's. I mean, it's all. It's.
I believe you. I just remember after I took my road test that we immediately went to the hospital. It wasn't like I went to the jail cell, and then I just remember going straight to the hospital.
I mean, they had to fight with you to get you going. You were, the time of the stop was 1:14 in the morning, and the blood was drawn at 3:53 in the morning. I mean, that's the truth.
I believe you. I'm not saying it's not. I just tell you what I remember. I honestly remember doing the sideway test and then going to the hospital.
All right. I've adopted the recommendation in its entirety, and you can go down to probation. They'll set up your orders appointment. Are you already on testing?
Yes.
All right. So I don't know if your protocol will change or not. They'll tell you down in probation.
Okay. Thank you.
Here's why the timeline matters. Alcohol metabolizes over time. So if you're still blowing double the limit hours later, your level at the time of driving was even higher. This isn't technical nitpicking, it's science, and courts rely on it heavily.
And you'd be eligible under Michigan law for termination at the halfway point if you met all the terms of probation.
Okay, thank you.
Who is Cherie Lee? Is that you? All right, come on up. This is 250229 SD, the City of Taylor versus Cherie Lee.
Aaron Wagner, on probation.
Very Curry on behalf of Ms. Lee, scheduled for a violation hearing today. I have had the opportunity to review the allegations with my client, specifically that there was a positive ETG reading that was south of 2000, about 1900. Positive. I've discussed it with Ms. Lee, and my understanding is she is going to be making a technical violation today, a positive test.
All right, ma'am, you understand everything your attorney just said?
Yes, ma'am.
All right, and did you go over the charge against you or the allegation against you for the probation violation?
Yes.
You understand it's a fourth technical violation. I could give you the full jail time of 93 days. You understand that?
Yes.
Okay, and it's the allegation is you tested positive for alcohol on December 28th to 25. You understand that, Ms. Lee?
Yes.
Okay, and did you go over your probation violation of Bites of Rights form with your attorney?
Yes.
Did you understand your rights?
Yes.
And did you sign and date the back of that?
Yes.
Ma'am, you understand that if you enter a plea of guilty, you'll be waiving those hearing rights. There will be no hearing of any kind.
Understand.
Okay. To the allegation that you tested positive for alcohol on December 28th and it was confirmed by a lab, how do you plead, guilty or not guilty?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to plead?
No, Your Honor.
All right, I'll accept the plea as knowing and voluntarily given. Anything, Mr. Barron?
Your Honor, I know that you're familiar with Ms. Lee's circumstances. She's been here represented by Mr. Fanta previously.
That one word just changed everything. By pleading guilty to the violation, she waived her right to fight it. From here on out, the judge isn't deciding if there's a violation, only how hard the consequences land.
She's still working. She's doing hair. She is still responsible for her one minor daughter who attends school from home virtually. She's a single mother in that respect. With regards to the positive test, I've spoken with Lee at length about that. She does acknowledge drinking any beer, and I've gone over that.
See my eye roll to that?
As well as that does contain some alcohol, and it is also a poor decision because an NA beer can easily turn into a regular beer. I've spoken with Ms. Wagaman from the probation department. I understand her recommendation of a day in jail plus a fan meeting, all other terms. My understanding, she has been in 100% compliance with all of the other terms. The only issue we have were these positive tests. I would be asking the court to consider, does appear that when she was on bond and when she was sentenced previously, she'd been on a scram tether at least twice before, and there was never a violation, no consumption of alcohol on the scram tether. So I'd be asking possibly the court to consider just simply reinstating the scram tether.
All right.
My concerns with the scram would be,
She's not getting a scram. You don't have to have concerns. Miss Lee, here's the thing. I have felt bad giving you on your VOPs, because I understand you're a single mom, you got some circumstances, right? You got a kid at home. So I have given you, this is her fourth use violation.
That's correct, between
So,
her bond and her.
You think you don't have a problem with alcohol, and you've got a big problem with alcohol. And I want you to know, if you think I'm stupid enough to believe that you had a non-alcoholic beer and you came up 4 times a cutoff on your ETG, I want you to know I'm not stupid. Okay, so you can lie to yourself, you can lie to your lawyer, even though it's not doing you any services to do so. You can lie to your PO, you can lie to me, but I'm not an idiot. So I think you're a liar now too. So let me tell you this. Here's the problem that people on probation with circumstances think all the time, right? I'm supposed to feel bad. Up here in my robe, I'm supposed to feel bad about putting you in jail for violating 4 times your probation. I feel bad. I I don't feel bad. I'm going to do my job. And I'm going to tell you what, you've had 4 use files, and I want you to know if you think I'm stupid enough to believe that you had a non-alcoholic beer and you came up 4 times a cutoff on your ETG, I want you to know I'm not stupid. Okay, so you can lie to yourself, you can lie to your lawyer, even though it's not doing you any services to do so. You could lie to your PO, you could lie to me, but I'm not an idiot. So I think you're a liar now too. So let me tell you this. Here's the problem that people on probation with circumstances think all the time, right? I'm supposed to feel bad. Up here in my robe, I'm supposed to feel bad about putting you in jail for violating 4 times your probation. I'm supposed to feel bad. This is on you. I didn't do this, you did this.
This is the breaking point. Judges can forgive mistakes, what they won't tolerate is being lied to. Once credibility is gone, every excuse collapses, and sentencing turns from leniency to correction.
Blood was drawn 3.5 hours after the accident, which tells me you were well above the cutoff, well above a super drunk, because it took them 3.5 hours to take you into custody from the scene. You wouldn't do the data master. They couldn't get a result, get a search warrant, wake me up in the middle of the night to sign search warrant, then take you to a hospital, get you checked in, get a nurse in a room to draw your blood. And you still came up at a 0.21. And you think you don't have a problem. We've asked you to go into treatment court. We've asked you to consider other alternatives. We've tried to make modifications. Ms. Wagaman's suggested previously modifications that are therapeutic to try and help you get better. You keep drinking. And so I think this Wagaman's recommendation on your 4th use offense on a super drunk driving while you're on probation for 1 when you got the 2nd is woefully inadequate. You're going to learn. I don't know what else to tell you. I have to teach you something because my compassion for your circumstances is just letting you do what you want. You got 10 days jail forthwith. Yep, thanks. Cartharney Properties, LLC.